being treated in juvenile court, and they don't understand that the Department of Corrections is still supervising the case and still involved. I was just talking to a reporter, and I said maybe we should have left it as blended sentences and never used the term youthful offender to begin with. But at any rate, you're here to kind of talk about youthful offender, how you see it. And obviously, there's a bill we're going to discuss in the next few weeks regarding youthful offender and how to whether or not there should be additional crimes added to the Big 12.
To the Big 12. Yeah, so I did hear Eric's presentation, which was fantastic. That means I don't have to cover any of the other things. I wouldn't have changed anything in what he said. And Lindy Boudreau and DCF has produced a really helpful chart that I often use that does basically boxed out age, type of offense, etc. Tyler often uses it as well. So I'm happy to send that over to folks, because whenever I'm talking about this, I always kind of have that over here, because as soon as you get into another age bracket, you could be dealing with a different set of statutes, and it's very helpful. So in terms of the Big 12, just to start, last year, we all talked about this during S4. You all passed an expansion, and then in the House that was amended, and it was expanded via the increase of attempts to each of the Big 12s. There was basically an increase with respect to violations of conditions of release attaching to Big 12s, which was really important to cases, because Big 12 cases by the very nature are fairly serious. And so when there's a violation of conditions of release, we thought it was really helpful if they all stayed in criminal, if that's where they are, or if they're all in family, they all stay over there. So we appreciated that last year, certainly, and the attempts. I see that S209 was put in this year, yesterday. The last 2 pages, section 3, I think the Executive Committee of State's Attorneys and our Executive Director's Office are in full support of the additions that you've drafted in there, and they align very much with what we recommended at the Sentencing Commission. As noted, just one circle back, the way we often talk about Big 12 is it provides the list that we may file in the criminal division, but it certainly doesn't command or dictate that it remains there. Either at the outset, we could always do direct file, as Eric mentioned, or later on down the line, either by stipulation, by motion of the parties, or by other means. So it doesn't command that it stays in the criminal division by any sense. And it certainly is tied into prosecutorial discretion in terms of where it starts, but it doesn't need to start there even under existing law. It can always start in the family division, which is always helpful, good reminder. In each case, even if the prosecutor is weighing their options, sometimes the prosecutor may wish to file Big 12 because of a public safety concern, because of an immediacy concern, because of a victim concern, and the ability to move forward very quickly. Because when you're dealing with juvenile jurisdiction, you're dealing with the potential for age outs, people leaving jurisdiction based on their age. So when someone on the older end of the juvenile landscape might have a shorter time period for rehabilitation, which is always interesting, which is why, on the younger end of things, there might be more, and I don't have the numbers in front of me, but more filings that are originating in the family division. I just wanted to touch on S209. You added in carrying a firearm. I believe just one slight change to that. I think that the term is a dangerous weapon in 13 VSA 4005. I think that's what it says in statute. So I would just change that to.
I think we made that on purpose.
Oh, you did that on purpose.
I did not. Yeah, we did, because we wanted to make clear it was the firearms that
emphasis on firearm.
When I've talked to prosecutors in my area as well as police, but met with both the Manchester, as you know, I think you were there at the Manchester meeting, and met with the local Bennington police. I think their concern is with firearms being used by youth who are committing felonies. So I asked Eric, quite frankly, to change it to firearm.
Okay, understood. That makes sense.
And obviously you could advocate for whatever, but I think the problem that was identified as firearms.
In terms of the sentencing commission process that we had homework with Judge Zone leading the way on Big 12 discussion and others. There was a group of individuals on the sentencing commission, Crime Victim Services with Jennifer Pullman, myself for the state's attorneys, a second state's attorney individual, Farzana Leva from Orleans County, and then the Department of Public Safety and really the governor's office joined in on a joint recommendation. And we recommended including, largely in line with what you had recommended, carrying a dangerous weapon or firearm while committing a felony, human trafficking or aggravated human trafficking, trafficking a regulated drug, aggravated stalking, and then the one that deviated from your recommendation was domestic violence, domestic assault type charges. And we also recommended that those all be or attempt to align with what you did last year. So that was the recommendation. And then the last thing I wanted to mention is the Attorney General's office endorsed that proposal in the sentencing commission process. Sorry.
I just want to make clear about domestic assault, and I consider it the most serious crimes in Vermont, and one of the most, unfortunately, one of the more common crimes. But I'm worried about creating Big 12 offense of domestic assault, and we use a real life example where a mother called the police about her two sons fighting. And one son gets charged with aggravated domestic assault. Ends up serving time in jail over it. The mother has never, quite frankly, never gotten over her guilt about having called the police and what happened to her son. She did the right thing to protect her other son, but it really puts, that's part of where I'm, coming from on that.
Yeah,
but we certainly are welcome here. We're open to discussion and obviously changes in the bill.
Yeah, I think that's an important factor because that's one of the ways that a domestic can come before the criminal court. The other thing we're seeing is, there are individuals living in the community, 17, 18, 19, that are in relationships that we have seen some dangerous trends exactly. So I think that's part of the back and forth.
Having worked with that mother for years.
Yeah.
Senator.
I have just a process question, and I apologize if Eric went over this earlier and I missed it. But so a Big 12 crime that it can be direct filed or petitioned to family court, but it starts in criminal court. Does that mean it sort of automatically creates at least some level of public record, either through the courts or the media?
It doesn't have to. So if you, when you receive, let's say you received an affidavit for aggravated assault and you're the state's attorney in Chittenden County, and in a few years after you pass the bar, and you are weighing the option, you have an individual that you could file in the family division, or you could do it in the criminal division for a Big 12. I think that's a call you can make, but you could certainly do a direct file in the family division where it stays confidential the whole time. It's in that family courtroom and that courthouse. The press is not allowed in. If there's any DCF records, they can be discussed there. They couldn't be discussed in the criminal division, open space. So yes, you can keep it in the family division from the outset.
Okay.
And that's about, that weighing, that discretion, exercise of discretion. Yeah.
Okay, that's helpful. So there is a decision point to be made as to whether or not it travels the default path or is disrupted from the very beginning.
Yeah, I often say presumptive because default means you almost don't have a choice, but you do have a choice even before it gets in there. You have the presumption of you can file here and potentially face litigation, try to keep it there, or change your decision down the line, or you could always direct file so it never enters that space with the direct file. And just by way of numbers, when I don't have the ages, but we had pending as of December 10th, 517 youthful offender cases pending. So within that group, there are Big 12s. I haven't dug into it, but within that 517 pending, there could be Big 12s. Sort of on the other end of the spectrum with that juvenile jurisdiction, juvenile delinquency, there were about 1,300 pending as of December 10th. So it just to give you a sense of some scale of within that YO land, there's some Big 12 cases probably. I just haven't done the next step. And I also don't know the age breakdowns. I was jealous of some of the age breakdowns of the prior witnesses. I thought that was helpful.
Well, that's all they have to pay attention to, is that small pool of people.
Yeah.
Go ahead, please.
Oh, I was just going to end with just a quick note on secure facilities, that we are a part of the working group that Tyler mentioned. We've appreciated that process. You all put it in your budget bill last year, and so we've appreciated being public facing. Our state's attorneys are incredibly interested in that, because we often are the ones that are called to task if an individual ends up being detained in an adult facility. So we would immensely prefer, if there was a safe space for younger folks that happen to be detained by whatever means, whether that's through a juvenile pathway via something that's happening in the family division, or via someone charged who's a young person who's not of the other age of adulthood who ends up in a detention type of situation. So the secure facility is essential to the pathway forward, and we want to see that keep moving forward. I was happy to hear the update from Tyler today about Middlesex. That's really the extent of the comments I had, and unless there's any other questions.
Any other questions?
And I submitted the recommendation that we had to the Sentencing Commission, so it's on your website.
Wait, we can't get to it. Did you have a question?
Thank you, Senator. I had a question, and it's one that I asked with the defendant general when he asked too, and I just was trying to get some feedback on this. Is it possible for when a Big 12 offense is filed in the criminal division, right? Is it possible for that to come back to the family? I'm not talking about a YO case. I know a YO case can come back by motion. We talked about that process this morning. That goes back for the consideration hearing, all that sort of thing. But let's say it's not a YO case, standard Big 12. Can that come back to the family division for juvenile treatment? And I feel like there's been some ambiguity in what I've heard in the answer. I'm just curious. But
I largely agreed with your interpretation that if it were amended, what you're talking about is amending down to a non-Big 12 for juvenile delinquency. Let's say it was aggravated assault and you charge it now as simple assault.
Yeah.
Is that what you're talking about?
That's one thing that Senator Bahowski asked. Exactly.
My assumption is that the criminal record that's been created is public for beyond the Google search, but it's also public. But then once you amend it down, it's no longer eligible for a Big 12, and it would have to be treated as a delinquency. Unless it were a non-Big 12 felony, where again it wouldn't be presumptive Big 12, and the prosecutor would have to work to file it back into criminal. So there would be a little bit of that, maybe it's back over in family for a little bit.
Yeah.
Prosecutor charges it as, let's say right now they charge it as an aggravated domestic assault. So it's not a Big 12, goes to family, and then there's some litigation as to whether the prosecutor wants to put it back in criminal. So it would depend. I think it would depend.
Right.
But would it automatically transfer down when it got amended to a non-big, that was sort of my question. If it starts in criminal court as a Big 12 crime and the charge gets amended to a non-Big 12 crime, does it automatically move to family court, or does it stay in the criminal court? Because kind of that's where it started.
Two things. If there was the ability to do if you lined up your paperwork where you moved, you amended the information, you amended it so it's now a petition, under Title 33, it's no longer a criminal filing. It loses jurisdiction, it loses everything in the criminal division. So now you're over in the family. So I could see some judges, and I would defer to the judge. Some judges might, depending on what's happening in their life that day, if there's not the ability to maintain in the criminal division, it's dismissed, it's removed. But if there's some lining up of the paperwork, there could be something resembling a pretty smooth transition into the family division for a delinquency or a non-Big 12.
But it wouldn't just stay in criminal because that's where it started.
I don't see how it could if it's
Okay.
it's not allowed. Yeah, if that makes sense.
It does.
Yeah.
As much as the law makes sense.
Yeah.
Other questions for Tim?
Thank you guys. And 10 liters too much for the record. I forgot to do that at the beginning. So someone emailed me.
No problem. Probably Annie Newman.
I'll permission to remain silent.
Matt Larry.
Good morning. Matt Valerio, Defender General. Good to be here for my first testimony of what will surely be many as we go through the year. I found this discussion, such as it was, regarding the Big 12 consideration by the Sentencing Commission to be profoundly typical of what I've experienced for the last 23 years with these committees, and that basically everybody who was on it effectively stuck to their roles. And with the, prosecutors and AGs seeking to expand the Big 12 or enhance the list in some way. And with those who were not in the prosecution and kind of victim area seeking to do something else. So there was never a consensus that was found at all. And it never even got to the point where we could legitimately take a vote to make a decision. There were some things though that occurred that I wanted to kind of bring up. I asked certain questions during this process. And the three main ones that I was asking about is, does expanding the Big 12 give us a better criminal justice system when it comes to the results that we're seeking to obtain for the youth if we expand it? And fundamentally, does it enhance public safety in some way? Do we get better criminal justice results? Do we get productive citizens, tax-paying citizens, law-abiding citizens by expanding the Big 12 and keeping young offenders? I don't want to even use the word youthful offender because that, but by keeping young offenders in the criminal justice system, as opposed to addressing what are very different needs in the juvenile system. And in trying to get to the answer to that question, I asked during one of our meetings of the various law enforcement prosecutors types who were there, I said, is there any data that I could provide you that would change your mind on the subject? And basically I was met with silence. There was no, so, this discussion that we had was not really much of a discussion. One of the things we do know is that youth in the Department of Corrections do profoundly badly when they are young people who are brought in through the adult criminal system. And you can see that the department, with the numbers that they have, does everything they can to kind of make sure that they aren't. And there's laws there to protect as well. We get to one of the things, there were a number of suggestions that were brought up. One of the things that I always had said, why do we need a Big 12 at all? To me, it's a political statement to the public that says, well, these are serious crimes, and so we have to treat them as though they're adults, even though they're not. And it doesn't matter what the results are because it's serious enough where we don't really care what the results are. The other thing I was asking about is, what are we really doing with these Big 12s when it comes to youthful offender and the like? All we're doing is saying, where are we going to start the case? That's all it's really about. You always have the ability to move to transfer a case to juvenile court. You have the ability to do youthful offender, which is a separate situation. What is the benefit of starting a case in adult criminal court for somebody who is 16, 17, 18, when you are talking about some of the suggestions to expand the criminal justice system. Really, it's to satisfy a political need of the citizens who want to see that. It doesn't end up in better results. And so as this discussion went on, it became apparent that we weren't going to come to any consensus. And the judge will report on what the ultimate results were with the, in his report. But I want to go back to, I'd like to have you at least consider the idea, one of a couple of ideas. One is asking the fundamental question, does this give us better results for young people than starting a case in juvenile court and transferring it to adult court based on appropriate criteria? What is the benefit, kind of a corollary, of starting it in adult court and then moving to transfer it either through youthful offender or into a juvenile case, purely juvenile case, by starting it in adult court? And we're going back to my earliest contacts with the Vermont criminal justice system when I was a freshman at St. Michael's College, and the Hamlin and Savage cases, and how the Big 12 and the cases that would start in whether they start in adult court or juvenile court, and they're like, that whole discussion there that kind of turned our juvenile justice system on its head for 40 years until we started to return to something that was kind of typical in the country at the time. Were we getting better results? Now, in the criminal justice system as a whole, we know that with adults, who are in the custody of the Commissioner of Corrections, statistical, depending upon what calculation you use, the recidivism rate tends to be overall somewhere between 57 and 60% overall. Are we doing better than that with juveniles or youth who end up in the criminal justice adult side of the system, or spend time in that side? Does the publicity help them down the road in living orderly and industrious lives and being tax-paying productive citizens? I doubt it. There was a statistic that was available at one time, and I haven't updated this, I have to say, in probably a decade. But the largest single factor for individuals who were incarcerated in the state of Vermont is that at some point in their youth, they had DCF contact. And that rate was like 95% at the time. The point
DCF denied that, by the way.
It was, at the time, it was provable.
Yeah.
I haven't updated it. The point is, there are a lot of folks who come in contact with the justice system throughout their youth that we need to, focus on addressing. And there seems to be some correlation, and I'm not saying it's causation, I'm just saying that it's a correlation between the two systems. And the point of this being, I don't know that expanding the Big 12 is going to get you where you want to get. I understand why these bills are out there. I understand why the public is interested in seeing young people brought into the criminal justice system in the way that is being suggested. I just don't see any evidence that that is in the best interest of the people who we're bringing in. And I don't see what the downside is in starting the cases on the juvenile side and transferring to adult, to the adult side if necessary. So,
how difficult is it to transfer a case up?
those are criteria that usually doesn't work that way because they're always getting caught. We have the Big 12. To me, it's
No, I know, but you have cases, I'm sure, where somebody has been charged in juvenile and then the state attorney would like to see it moved up to.
It's very rare. I can't think of any. That, normally those would be very serious cases, maybe state attorneys have some stats on that. The way our system is designed right now, we start, and if it is a serious enough case, it's gonna start in adult court, and it's gonna be.
Yeah, I'm just curious as to how difficult it would be to get a case moved up.
Well, it depends on the criteria that are established. That might be something worth talking about. The point being that those should be the extraordinarily rare occasions, as opposed to the opposite.
Well, how often do cases, you may not have this, or you may have to get it later, and so that, which is fine. How often are cases moved down?
Well, you see right now, the department has 500, there's 500 plus who are in the system that are youthful offender type cases. If you remember a couple of years, well, not a couple, maybe it's a little longer. Sometimes my memory is starting to get foggy, but when, my first decade or 15 years in the job, we had basically had a couple handfuls of people who were on youthful offender status, and it was being, really underused because there wasn't really any benefit to the youth for having that status. And one of the things, and I applaud you for doing it, is to give us a real youthful offender system that recognizes the science that's out there about brain development and the like. And so our numbers went from a couple dozen to, my last numbers were in the 475 range, but I take 515, which is what the department talked about. That sounds fine in the ballpark. Bottom line is we went from a couple dozen to 500 plus. And I think that's giving these youth a chance to be productive down the road. So anyway, when it comes to the Big 12 as a whole, there were a couple of proposals that were out there that I think the judge is going to reference in the kind of overall report that came from a couple of different areas, some not really from the Defender General's office. One was to eliminate the Big 12 completely and start cases based on age in juvenile court and move to transfer up. The other was to just raise the eligibility from up to I believe it was 16. Is that right, Judge? Yeah. And leave the Big 12 as it is and raise the eligibility up to 16 from 14. So that anybody who's under 16 is going to start in juvenile court.
Right now, to 12, you can be raised up, am I correct?
13 by motion.
Right.
Well,
yeah.
yes.
I mean, but there'd be a presumption.
Increase that to 16.
Right. And leave the Big 12 in place. And that was something that Marshall Paul had been talking about, the Deputy Defender General and Chief Juvenile Defender for the state. And that was something that was floated, none of which got any real traction in the committee. But one of the things that the Department of Corrections really does, they don't want to have young people in there. And one of the things that was sort of touched on was, the segregation that has to occur is actually pretty difficult for a youth who gets put in those positions. Luckily, there aren't very many of them. I guess they had one who was 18 and they had a few more that were younger, but they are on detention. They're not sentenced. That's difficult for the department to handle. And psychologically, it's very difficult for the youth as well to be held in adult centers, even if segregated. It's difficult for adult offenders and people who are have pending charges. So in any event, I understand where the suggestions are coming from. What I would like to see is us keep our eye on the ball of what we're trying to get at. which is better results for the people who end up in the system, as opposed to, satisfying necessarily, a understandable public outcry, but one that doesn't get us the type of results for these kids who are caught up in the justice system.
Senator Bowski has a question.
I do, and it maybe is a question for Tim, because it would be helpful for me to understand kind of like what, I understand that it doesn't happen very frequently, but what the process is for transferring a youth up from the family division and how difficult it is. Like I said, I know it doesn't happen very much, but it would be helpful for me to actually understand that. Is that a question for you, Matt, or would it be better answered by Tim?
I will tell you this, I've been a lawyer for over 35 years, I've never seen it. So we ought to either under prior law or current law. Marshall, who is the juvenile defender, may have more information on it than I do. I've never seen it. So maybe Tim has more information.
Okay.
Yeah, and in some ways I might also defer to how the courts might see that process. But my understanding, being next door neighbors to the juvenile prosecutor in Washington County for a couple of years, she did try to do it on a few occasions, I believe, so I could talk with her and get an understanding of that process.
Okay.
But it isn't necessarily timely in some ways because you're competing with the other cases that are happening, and so depending on what's happening with the case, you're battling with the docket. And just as something to think about, if you're trying to transfer it up, you're trying to make your way into an already enormous criminal caseload. And I know we're talking about all this stuff in general next week on the 10th, but I will talk with a couple of our juvenile prosecutors and see if they could almost do like broadly step by step.
That would be really helpful for me to understand. And then my other question, and you potentially answered part of it, is sort of the percentage of transfers in each direction. Like what percentage of transfers are happening in the upward direction versus the downward direction? And again, I don't know who this is the right person for, but it sounds like very few are going up.
Yeah, I mean, the courts may actually have that data in some way. I don't know. They have a new fancy system that tracks things, so I hope they would have it. But my guess is you're talking about extraordinarily small numbers. You may be able to count them on one hand if you needed to, maybe not even use all your fingers. Very, very small numbers.
In either direction?
No, going up.
What about going down?
I think there's a fair number. I mean, definitely going into youthful offenders. They're definitely going into, you're talking hundreds.
Okay. And so one of the things that came up last year was this sort of ping pong effect of transferring the cases from adult court to family court. If we were to eliminate the Big 12, would that eliminate a lot of that issue? Because they would presumptively be starting in family court and there would be a tiny percentage that might be transferred up.
Right. I think the ping pong we were talking about, though, had to do with cases that would start in adult court, go down, and then go back up for some purpose, and then have to go back down again. Like we talked, this was something that Tim was talking about. It's not just going from one to the other. That type of transfer, one way or the other, is what courts make decisions about. They're designed that way. But there are times when one court loses jurisdiction, which is what Tim was talking about earlier. So there's an amendment of the charge, or a charge is dismissed from a Big 12 charge that ends up, now the court doesn't have jurisdiction over it for the age of the kid. It has to go down to juvenile court, and maybe the prosecutor will want to bring it back. That ping ponging is, I think that's a different issue.
But presumptively, if there was never it starting in criminal court because of the Big 12, you'd eliminate a whole step and you would just make the transfer once.
Correct.
So it would eliminate that back and forth to some extent.
Right.
Okay, thank you.
To me, there's a little bit of a fiction with that, only because, the court, the jurisdictional prerequisites for either juvenile court or criminal court, especially in particular counties, like when one judge is sitting on all three dockets, it's like we're just taking off hats. You know, in other courts, you know, Chittenden County is always an issue because it's unlike everywhere else, because there's so many more judges and different courts and that sort of thing. It is, you know, I think I'll defer to the judge on this one, but it's, I don't want to overstate these procedural issues that they come up in odd cases, you know, and I don't like the idea necessarily of, you know, creating general policy to deal with the outlier. And that's, I think, sometimes what bubbles up here is you get the outliers get a lot of attention, but the vast majority of things are going okay. So I mean, I'll defer to the judge.
Senator Baruch has a question or comment. Then
So, you also, so Matt, I hope I'm understanding you correctly. And I think you have a point, which is, and I think this is where Senator Bohovsky was going to, is the way it stands now, the default sort of, although it is an option that's being taken, is they go into criminal court and then hundreds move back down to family court, meaning that hundreds are disadvantaged for life by the criminal record created because they didn't start in family court. Is that?
At least even if the record is gone, the publicity that surrounds the cases is always available. You know, it's not like the old days where there was no internet.
Mm-hmm.
You always have a record, whether you know, on the internet.
Well, that's what I mean. So even if we got rid of, you know, we expunged the criminal record,
Yeah.
it would still be out there in Google land.
Right.
Okay, so or I guess you're saying it didn't necessarily come from your office, but the idea that you're floating is if there were no Big 12 and all of these cases originated almost by default in the family court, we'd avoid all of that, and then we might increase by some number, the number that transfer up, but that would probably be a relatively small number of cases transferred up, but it would be an increase. But that all seems to make sense and more sense than the current system. So what I'm wondering is, what is the argument that you confronted in this group with when that was put out?
There wasn't much of an argument. There was just a kind of a rejection. You know, there were folks stuck with roles that basically said we want to expand the Big 12 to whatever the number are. They to the credit of prosecutors and victims groups, they, you know, tried to make it palatable on some level, but didn't address the fundamental question of really, does this aid in public safety and better results? And you know, there is some data out there that significant data that suggests that it doesn't help. So you know, we were basically at a standstill. I don't think that, you know, it's not like settling a personal injury case where somebody asked for 100,000 and somebody else wants 50,000. Now we're going to give you 75,000 because it's somewhere in the middle. They were conceptual loggerheads that were not really being breached.
And I can understand, just as a comment, I can understand when there's a serious crime in a community, people are focused, laser focused sometimes on that incident. They're intensely interested, and if a prosecutor files in family court, no information is revealed, and that's incredibly frustrating for that community. So in the incident I talked about earlier, there was a decision to begin the case in criminal court, but the prosecutor immediately said, but it can be moved down. But I felt as though a critic might say that that was a sop to the community, politics, as you were talking about it. But the youth involved, the ultimate determination is that they should have sealed records. But at that point, the thing that's unsealed is the worst version of what they got.
Right. And that is, and I don't blame anybody who runs for office and has a constituency who feels the need to accommodate that constituency. I have to look at this, however, based upon the best interests of our clients. And that is not always the same, it's not, sometimes not even often, the same thing as the desire of the constituents who elect people.
Senator Morris.
I'm gonna try to wrap my mind around this, Mr. Valerio. It appears that I read between the lines your thoughts on the Big 12 and the increasing of the Big 12, obviously. It appears as though it's a lot easier to move cases down from adult court than it is to move cases from family court up. And I understand your concerns about your clients, as you so graciously put it.
I'm not saying it's more difficult.
No, from the testimony we just heard, it's more difficult to move it up, looking at the percentages we're talking about.
Is less timely when you're dealing with a situation, for example, for a felony that's a non-Big 12.
I get distracted by the dogs too.
I would say that it is, by its very nature, not as
I
timely.
think we've gone into a conversation about a possible change that in the bill that is
Right. And I'm not even
more
talking about a bill right
appropriate
now. So.
for discussion as we take up S209 on the 18th of January. And I think at that time, I'd love to have a discussion, but I'd also like some figures. We changed the law, I believe, in 2018 to allow for 10-year-olds to 10 to 12 wouldn't be adults. Correct. And then 13 and 14 could be moved up from juvenile court into adult. And I'd like to know the numbers of those people, kids who were moved up and how difficult it was, blah, blah, blah.
Yeah.
So one of the things that you're considering, and we could use information on that on the I plan to start taking that up on the 18th, with more about the ghost guns actually on the 18th. But anyway, we could use information about how you would deal with 15 and 16-year-olds, and also, but getting back to the youthful offender status, also another issue is the publicity that comes along with a kid who's 16 and charged in adult court. And then that information is available publicly, and then it's decided to even dismiss the case or move it down into family, and what are the results of that, how to deal with that. Right?
Yeah. And, I was here prepared to basically talk about what went on in the Big 12 study committee and how,
Yeah, no, I
the
understand
art
that.
side. So, I can definitely, either myself or Marshall or both of us talk about the, more details. Senator, I do think the question you're asking, though, you're talking about an extraordinarily small number. And you also are talking about the discretion of prosecutors to even make the attempt. And it may not even it may have nothing to do with difficulty. It might just be, it's
And I
not.
appreciate the answer, but there was more to my question, obviously, and so with the existing Big 12 as it is right now,
Yeah.
is the system working? Is justice being prevailed with the present system, in your opinion? Because you brought this to our attention.
I don't think that young people who end up in the adult criminal justice system are getting the type of positive results that they would get if there were other options available to them, even if charged with a Big 12 crime. Now, there are life in prison crimes that are there. There are a lot of factors, all of which are subsumed in youthful offender, right? Amenability to treatment, age of the person, experience, all the things that go into that. I think we've made a lot of progress since youthful offender has been expanded. Everything comes with warts, nothing's perfect. But compared to what we were doing 15 years ago, I think we've made a lot of progress.
Well, I guess we'll continue this conversation when 209 comes up down the road here.
I would imagine,
Youthful offenders, certainly, there's just general confusion out in the public for what it is and what it does. But I think it has been more successful than meets the eye, quite frankly.
And a lot of it's not done in public. That's why it's not understood. And it's not done in public for a reason. But, you know, I can point to specific examples of great successes, but frankly, by law, I'm precluded from doing that.
Yeah, me too. But there are, part of my stack here is a 65-year-old man who I worked with when he was 15. He had adult charges when he was 16. And now he lives in Massachusetts and can't get a hunting license because of his record.
Yeah.
And he's 65 years old and he's a grandpa, and, you know, 50 years later, that record is still out there. So I do have a sensitivity to this public record issue.
When I was first, I'll just close with this one anecdote. When I was a young lawyer, I was probably 26 years old. I've been practicing 2.5 or so years. I did a relatively serious multiple aggravated assault case involving a stabbing in Rutland with a youth. The incident occurred when the client was 16 years old and was filed in adult court, as was typical for 16 and 17-year-olds at the time. We tried the case. There were multiple charges and the like. He ended up convicted of one of the aggravated assaults. This was a brawl that had occurred, and a knife was pulled during the brawl, and he was convicted of stabbing one of the individuals who almost died, but was saved by some good work for the doctors. Nevertheless, sentenced to ultimately 1 to 10 years to serve. He was good inmate. He was released after to the community after, I think it was 8 or 10 months incarcerated, and then didn't have any violations of his parole over the next 9 years. Finished his sentence and attempted to do various things in the community like he'd always wanted to do: coach, be an EMT. Licensure issues came up because he had a felony on his record. One of the things that I thought, I always had a thing about this particular case, thought that it should not have gone exactly the way it did. But ultimately, with some changes in the law here in Vermont, and Marshal Paul and I were able to get this guy's record expunged when he was 50 years old. And he ultimately was able to then go coach and do all the things that he wanted to do. But in the meantime, he had a family, no other crimes, all of that sort of thing. And, but was unable to like fully contribute to his community, even go to like school functions and things like that for his kids because of this violent felony that was on his record. And I think if youthful offender was available to him at that time, it would have been a perfect example of the type of thing that was available. And I have a lot of other, now that I could talk about because it was adult, always was adult, ultimately we were able to get it expunged after 30 years. But imagine what we can do, and we have a little bit with our youthful offender as it continues to avoid wasting, 30 years. Yeah, as to the individual. That's, these anecdotes, they don't make, again, you don't want to make policy based on one or two, but these are just examples of, I think there's more than that out there. So
the likelihood of them committing crimes after 20 years is no more likely than you or I.
Right.
Just
Bill,
quickly,
and then
both of those cases occurred basically before the internet. So, if you imagine it now, it's that problem plus any person with any device can just Google the name theoretically and bring up the original criminal arrest, notice in the press. So it's so much worse than this case and that case
yeah.
in that sense.
I will admit, sometimes I get these nasty emails and I will Google the name.
Right.
Yeah,
And,
I mean, to Phil's point, I certainly know someone who was picked up for something. Ultimately, it was deemed that they were illegally picked up for that. And the one thing their lawyer couldn't get rid of was that initial press release. Like, I can get rid of everything from the system, but the public will know because this is here. And so there's that, but like also as I'm hearing your point, we shouldn't be making policy on the smaller numbers, but the bigger numbers. But what I'm really hearing is the small numbers are the numbers that belong in adult court for our juvenile offenders. The big numbers are the ones that start there and are ultimately getting moved down. You're telling me hundreds of cases are getting moved down.
Oh, we have over 500 in youthful offender now. Yeah, so it used to be 20.
back when we started that,
Yeah,
you remember.
I do. We worked for a really long time to get youthful offender being a meaningful thing.
You and I.
Anyway, all right, thank you.
Thank you.
Any other questions? Happy.
Thank you, Matt. Did you have one?
Well, I was just gonna add, in response to Senator Bowski's question, I think Tim's gonna look at this anyway, but there is a detailed process laid out in statute as to this transfer. It says a motion has to be filed by the state's attorney, then the filing of the motion stays the proceedings. Then there's a long list of family division has to hold a hearing, has to make a finding, and then there's a lengthy list of criteria that the family court has to consider. So it's laid out specifically in great detail.
Is the other side of that process also laid out in statute, the process of transferring down? I'm wondering if they're sort of similar or if one is somehow more arduous than the other.
And this segues into the question I asked him earlier. So the answer to that is yes for the transfer down for youthful offender status. So that has also a detailed process, what factors have to be considered, how the motion gets filed, what the consequences of the motion, all that is yes, there's a process. It looks fairly parallel, or at least comparable. So yes, both processes are there for youthful offenders, and I'm still wondering about the question of, and maybe the data that's being referred to is only for youthful offender cases, but can a case be transferred down if it's not being converted to a youthful offender case? In other words, take the Big 12 offense that's number 12, burglary into an occupied dwelling. Often brought out as, why is that a big deal? But it is, it's number 12. So if burglary into an occupied dwelling is filed as an adult charge, as it's supposed to initially, it becomes filed as a Big 12 in the criminal division. Can it get transferred down to the family division, not as a youthful offender case, but just can the case be transferred down? And if so, what's the legal basis for that? For that, Senator Bajowski, there is no process in statute. But it may be that it doesn't happen. I haven't been able to get an answer to that.
An interesting comment, because one of the things that the Sentencing Commission that Judge Zone's report on was to look at was whether or not that should be a Big 12.
That's right.
So,
Good morning.
Judge, you've heard the questions, you've heard
Heard
the
it.
comments.
I have.
We're pleased to have you here, and I should have said Happy New Year to Tim. Say it to you and maybe to the other two as well.
It's a pleasure to be back and see everyone. So Tom Zone, Chief Superior Judge for the record. The first thing I would note is I've heard a number of requests for data. I have actually already sent an email to our trial court operations. I haven't heard back yet. If I hear anything during my testimony today, I'll let you know. I don't expect necessarily to get the numbers for you today if they are
Well,
available.
if we have them on
But I want to
middle
find
of
out,
January, that would be
and if I
helpful.
have any follow-up questions about specifics, I'll let you know, or please let me know. But as I understand it, you'd like to know what's going up, what's going down, what does it look like? And so I will try to get that type of information for you. Senator Bajowski, you asked a question, we're talking about transfer. The one question you asked earlier today had to do, as I understood it, what if it's a Big 12 and then it's amended and it's no longer a Big 12? There's a statute for that. in my opinion. And that's 5203 of Title 33, because it says the court shall forthwith transfer a case if it doesn't, if it's not where it's supposed to be. And so I can tell you that a number of judges, if they have a case and that amendment is filed, they don't wait for a motion to transfer it. The judge will immediately, without request, transfer it.
Okay.
Likewise, if you have a case that might be filed as an adult case having two counts, one count that would be Big 12 and the other count that's not, and the judge does not find probable cause for the Big 12 but finds probable cause for the other one, a judge would likely transfer that also under that statute forthwith. You also were talking about confidentiality of youthful offender, and that's an issue that I know many people have questions about, and the statute does provide that for the cases of 18 to 22-year-olds, the hearing in the family division on whether or not someone's going to be treated as a youthful offender is a public hearing. All other such hearings under the statutes for youthful offender determination are confidential and closed. But that one hearing is something that you have statutorily provided is open to the public. There was testimony this morning by DOC, and Josh Rutherford made the comment, as I recall, something along the lines of, we'll do whatever you give us, we'll deal with. I think when he was talking about the impacts of your decisions. And when I heard that, I went, yeah, that's where we are. Because the reality is, whatever policy decisions that the legislature makes with respect to Big 12 or any other statute, we will implement in the courts to the best of our ability based upon the resources we have and following the law. And so when we hear questions about should we start here, should we start there, I will not weigh in on those because they really are policy decisions. There's, as I think Mr. Valerio talked about, well, there's a public safety component that is often urged, and then on the other side, there's let's look at the result component for the youth, and that's a balance that is done in this room and in the chambers that are in this house.
Mr. Chair, I appreciate that, and I hope I'm not. What I hear you saying is you want to remain neutral on the policy question. Let me frame it this way. Let's say that Matt's hypothetical, I won't call it Matt's hypothetical because it apparently came from somebody else, but you've been describing it to us. Let's say that there was no Big 12 and these sorts of offenses routinely went to family court and then if necessary were transferred up. Logistically, in your role as someone who's looking at resources in the court and trying to avoid bottlenecks or unexpected conflicts, would that kind of approach simplify things, streamline things, or the reverse way, make things in some way logistically or institutionally harder to manage?
I think that simplify would be the one I would pick out of your choices, because right now it can go in either place. You can direct file, you can go up there. So it would simplify so that everyone knows if X happens, it's going into this division. And so that would be a simplification.
And this is a thought experiment that's sort of building out in little ways, but to me, that's a big thing to hear you say, we'll simplify the process. Would there be any negatives that you could foresee, not on the policy side or what the community might react to the change, but if there were no Big 10 and we were directing these cases at family court, and let's say our stated purpose was to avoid the hundreds of transfers down with the attendant problems for people's later reputations, are there negative consequences that you can foresee just logistically?
Sitting here today at this minute, I would be uncomfortable saying yes or no to that question.
Okay.
That's the type of situation I'd actually want to sit back and think about much greater detail. Because sometimes you answer that quick, I can't see any negatives, or yes I do, and you walk out and go, wait a minute, what about this?
Yeah.
And so I would like to give that some thought before I would respond to that.
And I would appreciate if you would. The more we talk about it, the chair had talked at the beginning about trying to get at the problem of people who get bargained down or in some way move down into family court. but still have that vestigial record that trails them. The more we talk about it, the more I find myself just wondering, what are the practical consequences of just directing things in a much more straightforward way to family court?
And that's a good segue into the Sentencing Commission report, because there was different views on that. The Sentencing Commission, as Mr. Valerio talked, did discuss this issue. And also, Mr. Leaders Dumont also talked about the issue of, there was two proposals. There was a proposal to expand the Big 12, and that was a proposal by the Executive Committee of State's Attorneys, Vermont Center for Crime Victim Services, and Department of Public Safety, and the Attorney General Office did concur with that. The report was filed as required under the statute, and my question is, would you like me to send a copy to your, to Ben right now, so that each member of the committee can get it?
Yeah, I think
The question is,
it's on our committee webpage. Isn't it?
can we get it?
I just sent it to Ben anyway, to belt and suspenders.
We can't get to our committee webpage today.
I think there's some IT that supposedly we can now. I don't know if you guys
Oh,
can yet,
okay.
but hopefully.
But, well, if you have trouble, you need copies, I'll bring them over this afternoon. If you need that, let me know.
It's just,
I think it's already up there.
Okay.
Okay.
So the proposals that the Sentencing Commission had were, again, they were the policy issues. And those are the difficult decisions that the legislature has to make. And the one topic did come up about burglary into an occupied dwelling.
Yep.
Because the current statute is that an occupied dwelling is whether it's presently, or it doesn't have to be occupied at that minute. It could be whether it's used as a dwelling
Right.
part-time. And the question comes up about seasonal dwellings unoccupied.
Yeah,
So,
we have dwellings up on Sucker Pond that you can only get to with an ATV, and you can't get there in the wintertime. And yet if somebody gets there and breaks in, it's a Big 12 offense.
and again, that's a policy decision for the legislature. But I don't have, again, much more at this time. If you have any questions, I'll be happy to
I
answer.
do, actually. How difficult would it be to have cases that are filed, if the person is 17 or under, the charges are filed in adult court? How difficult would it be to have that be automatically confidential until a decision has been made about whether to either treat as YO or treat as a family court?
There's the public access to court records. There would need to be changes to existing statutes. So I don't think it's a single statute fix. I think there's several layers of it.
Would
that
it be a
have to
policy? I know in other states, I read the Boston Globe almost every day, and there are crimes committed and they're pretty serious, but the name of the youth is not provided because they're under 18. I'm wondering if those states.
I think we would want to make sure to bring in a constitutional expert on that, because I think we're gonna run into free speech and
Understood.
press access, and so I think if that's the route we take, we wanna
But
hear
if
from.
a 17-year-old.
Yeah, I'm not a constitutional expert, I'm just.
Right, no, I understand that, but if a 17-year-old shoplifts at the local convenience store, you don't get that name.
And I think that's because that applies to
Because they're
all
charged
17-year-olds in
juvenile.
family court.
Because they're charged in family court. But if the 17-year-old is charged in Bristol, Vermont with murder, that name is out there, no matter what the final final disposition is, whether it's treated as a youthful offender or treated as a juvenile. What I'm suggesting is, that person is still a juvenile at under 18, whether we've raised the age or not, it's still a juvenile.
Isn't this Jeanette White's bill from 3 years ago or 4 years ago, where it came out of GovOps, got vetoed,
Right.
and and then it stopped there, but I think it was essentially what you were saying.
Yeah.
It was age-based and you couldn't report anything, until it was determined which court stream it was gonna
Yeah,
enter.
I think so.
Yeah,
I think it was vetoed, but
Yeah.
I don't know that it was unconstitutional.
So I brought this up to someone who sort of, the way they laid it out to me, and again, I'm no constitutional expert, was that the family court is sealed as a whole, and so that is okay. But when you start carving out aspects of the criminal court, that is not okay, because the criminal court is sort of constitutionally a public record. Again, not a constitutional expert. I would want to get someone in though to like help us hash through those details.
I would offer, I think it's fair for me to offer only that you have identified the different arguments that would be made. It should be that you may want to look at that from the perspective of where does it start?
At
Yes.
the very least, so if I go and Google the name, and I find out that Googling the name of when he was 16, he did this and this and this. But I also can find out that it was dismissed or placed in family court or treated as a youthful offender. Would that be helpful public knowledge? Because we don't know what happens. I mean, nobody knows what happens after, once they get into family court or once they get to youthful offender. It's confidential.
There is, I believe, 33 VSA section 5510C that does allow the child, the youth, to speak publicly with assent of the attorney as well as their guardian or guardian ad litem. So I think there's a limited ability of someone to say, I had a hearing and here's what happened.
Right. But at the very least, it's an issue, I think, that you don't, in the Google age, you don't want.
Well, I think it's fair to say that many of the statutes and laws that
I
we
think there was
deal with.
something called the Scarlet Letter, was a book years ago.
But
I've
many
heard
of the
of that
statutes,
book.
many of the statutes we're dealing with were written in the pre-internet time, and that's one of the challenges that you face on the legislative side, is to try to figure out how to make it all work now.
we could add adultery to the Big 12.
I wasn't suggesting
That is how you get your scarlet letter.
but
I will get, if
I
I find
believe
out
that
more on
was the
data,
Scarlet Letter.
I'll let you know.
Yes.
Absolutely.
I'll get you the data information, or lack thereof. I'll let you know whichever way we're going. Thank you.
Are there other questions of the judge? Judge, and thank you all very much. It's
Thank you,
been a
Judge.
very helpful hearing. Helps me, it adds more questions than I had expected, but the history, what Matt Valerio, I'll take some credit for this way back when. Along with Erica Mathis, believe it or not, she was a strong advocate for youthful offender laws back when they were popular.
Matt, you missed your shout out.
Yeah. But it was when you were a young lawyer. Remember those days?
I was never reading.
I was a young legislator.
Sophomore leg or something.
Do we want to go off